This is the review lecture from Module 9, focusing on due process and civil liberties. First, I'll just go back over a few things that we covered in the overview Module 7, where we were kind of doing a glossing over of due process and equal protection, or civil liberties and civil rights. I'm just going to recap a few things from that module. As far as due process goes, there are two due process clauses in the Constitution. They're found in the Fifth Amendment and the 14th Amendment. You'll notice the language of these two amendments is nearly identical. For both of them, state action is required. They will not apply to the conduct of private individuals or organizations. However, when a government entity is ultimately responsible for or in control of a private organization or person's conduct, the due process clause will apply. So the court is going to look at the degree to which private conduct is being enforced by a government entity. There are a couple of cases in the textbook that gave examples of that to kind of help you understand what we mean. But generally speaking, the case law is going to be directed at government employees or laws passed by Congress, laws passed by the state, or the activity of state agencies. So state action is often very clear. There are just some instances where private conduct is intertwined with government action, and then there's kind of a delicate analysis to determine whether state action is actually present or not. For both clauses, you'll notice that the term is person, not citizen. So these protections are afforded to more than just the citizens of our country. They can belong to even to business organizations. And this is because business organizations are private entities. They are just a legal grouping of individuals who have a common property interest. And so collectively, that property interest is protected by the due process clauses. Due process can provide protection for immigrants, as well as, in some instances, to enemy combatants. And that was the subject of the Guantanamo Bay cases that we looked at in a previous module. Those cases are very specific to the facts, involving a balance between national security and the prosecution of war, and then fundamental fairness towards all people by our governments. Generally speaking, just the basic due process rights of notice and a hearing and a partial jury, those are the ones that are afforded even to enemy combatants. There are two types of due process, and I don't know that we necessarily touched on these two types in Module 7. So I'll go over those a little bit more in depth as we move along, but generally they are substantive due process and procedural due process. So it's two sides of the same coin. You can look at it that way. On the one side, due process means that there are things our governments cannot do. They cannot infringe on certain freedoms, certain liberties. And then on the other side of the coin, there are things that government has to do. These are the procedures government must follow before it deprives us of life, liberty, or property. So for now, we're going to focus just on substantive due process, the things that government cannot do. Most of those freedoms are enumerated in the Constitution. I went over those that were found in the original articles in Module 7, then also the Bill of Rights, and then the Reconstruction Amendments, the 19th Amendment. Those are substantive due process protections. Government cannot infringe those. They are enumerated in the Constitution. But there are also unenumerated freedoms that were recognized by the Ninth Amendment, where our founders said that the Bill of Rights is not a complete list of all liberties. So our courts just have to apply an analysis to decide whether whether and to what extent some other liberty is fundamental, is so fundamental to the notion of freedom that they are protected by due process, even though they're not actually listed. And the first one to be recognized by our courts is the freedom to contract, or economic freedom. That was recognized in the U.S. Supreme Court case of Lochner versus New York. I don't remember the particular facts of that case, but the point that you need to understand is that for a long time, historically, the courts were just concerned with enumerated freedoms. And it wasn't until after the 14th Amendment was ratified, and just coming at this from the point of history, the progressive movement involved efforts by state governments to start regulating businesses to provide for consumer safety, employee safety, those sorts of things. And so as states began regulating businesses, those businesses began fighting back and looking for ways to prevent the government from interfering with their businesses. And so they began relying, or attempting to rely, on the due process clause. And they simply were not really successful until after this Lochner decision. That's when we started to see the court apply or to recognize a freedom to contract, an economic freedom, substantive economic freedom. And so when the court does that, it's going to apply a test like we have for all of the other due process liberties. This time the test is there a legitimate state interest? And is the law being applied arbitrarily or just in a discriminatory or irrational way? Before the 1930s, definitely before the Lochner decision, courts were reluctant to uphold any restrictions on the freedom of contract. Our country had been applying laissez-faire economic policy for so long. It had allowed our economy to flourish, make us into a world power. And so courts were very reluctant to allow government interference in business at all. And it was just this gradual process in the early 1900s where the court slowly started becoming more comfortable with this notion of a substantive freedom to contract. And so after the 1930s, though, the regulation of private businesses became less controversial and were more likely to be upheld. And so now you and I living in modern day, where, it's kind of second nature to know that there are state regulations of businesses in many, many ways that protect the safety of our food, protect the safety of the drugs that we take. And these are things we take for granted now, but before the 1930s were really, really controversial. But they were controversial then because of this recognition of an economic freedom. And I have to take a little bit of a break. This material we're on comes from chapter 9, but what I'm going to talk about next is material that you would find in chapter 10. And this chapter focuses on economic freedoms and their protection outside the context of the due process clauses. And I'm tying them in to kind of shorten the amount of material that you have to be responsible for. So I'm only going to kind of touch the surface of these other economic freedoms. So there is a protection in the original articles that would be considered a protection of an economic freedom. And that's found in the contract clause of Article 1, Section 10, where it says no state shall pass any law impairing the obligation of contracts. This clause was written to prevent states from enacting laws that impaired the ability of creditors to enforce their rights against debtors, which had been a problem following the Revolutionary War. Not so much a problem anymore. But all the way the courts have applied that language, they've kind of whittled it down to the point now that the contract clause really only protects the right to insist on performance of a contract. But pretty much every other aspect of a contract can be regulated. Businesses are regulated regularly by governments. The takings clause is another place. This is in the Fifth Amendment. That provides that states cannot take property for public use without just compensation. This limits the power of eminent domain. You've probably heard of eminent domain before. It's where government tries to exert power over privately owned property. This protection, the takings clause, it has been the subject of selective incorporation. So the takings clause applies through the 14th Amendment to state governments just as much as to the federal government under the Fifth Amendment. The first aspect of it is that the government has to justify the taking at the outset. It has to show the public use that the property is intended for. Now, our courts are pretty deferential to that determination. A common example of taking property, or a reason to take property, is if the property is blight. I mean, if it hasn't been taken care of, if it's run down, if it's got hazardous waste on it, or if it's part of some larger beautification or improvement project. You'll see takings in those contexts most often, and it's easy for the government to justify the public use. Courts defer to the legislative branch in deciding whether to exercise eminent domain. And so as long as this sort of development of property goes, what may happen is the government condemns the property and then allows a private developer to do the work of improving it. And so it kind of may seem unfair to the property owner. They see their private property getting taken and they immediately given to a private contractor to develop it. So it looks like favoritism, cronyism. But like I said, the courts are pretty deferential, and as long as this is part of some larger redevelopment, community improvement, they're going to allow the taking. What's going to like the second aspect of it is the payment for the property. So the courts will require the owner of the property to be compensated at the fair market value of what has been taken. So that is how the private property is protected. They get the monetary value of it, even if they lose the actual property. It applies to all forms of property, not just real estate. It applies to personal property, intellectual property too. It includes taking title to property. It can include physical invasions of property, like a government kind of encroaching on the premises through air. I mean, it's pretty broad what we mean by property. It can even include regulations that go too far, as the language. Has the regulation gone so far as to be a taking? Those are just some examples of the way takings occur. But let's get back now to substantive due process. We're talking now back with the 14th Amendment, and I mentioned economic freedom was the first of the unenumerated substantive freedoms to which the due process clause would apply. Well, there are also personal freedoms, non-economic freedoms, and this is where you're going to see most of the court cases today. Economic freedoms aren't quite as protected as they used to be, but personal freedoms are. So we'll look at that for just a moment. If a personal freedom isn't specified, isn't enumerated in the Bill of Rights or somewhere else in the Constitution, the court has to determine whether they should be protected, what civil liberties should be protected that aren't specified. And they do that through an analysis of the history and tradition of our country and how have our laws protected that liberty in the past, and should they continue to do that in the future. And if they decide, yes, this particular liberty is fundamental and has been protected through the history and tradition of our country, the strict scrutiny test will apply, and the government will be prevented from interfering with it. Other freedoms that are not deemed fundamental do still receive some protection. They're just a different test will apply. The rational basis test will apply. So in the last module, we went over the differences between strict scrutiny, intermediate scrutiny, and rational basis. So with a fundamental freedom, you get strict scrutiny. All other freedoms are just given rational basis scrutiny. Most, if not all, of the personal freedoms that the substantive due process analysis would apply to involve the concept of a right to privacy. And we'll look at that right to privacy in depth in Module 12. We're not going to go into that just yet. Due process protection also is implicated in civil lawsuits, private lawsuits. And there is a substantive aspect of it in private lawsuits, as well as a procedural aspect of it. Since we're just now talking about substantive due process, I'll tell you the substantive due process application in private lawsuits. When one citizen sues another citizen, obviously they're in court, and the courts are going to impose monetary awards. They're going to either give a party or force a party to pay money to another party. They'll involve juries. They involve court employees. So the state action requirement is easily met. The court is the state in that situation, and their employees are the states. So that's why due process becomes implicated even in private lawsuits. Courts presiding, like I said, are going to enter a judgment for a monetary award to a successful plaintiff. And most of the time, those awards are just the amount to compensate the plaintiff's loss caused by the defendant's activity. But sometimes a jury may find that the defendant should pay a sum of money to the plaintiff to punish the defendant. So it's more than what is needed to compensate for the plaintiff. And so it's called punitive. It's a punitive damages award. It's a punishing them for conduct that is particularly egregious, particularly wrongful, like an intentional harm, gross negligence, or recklessness. Those awards are called punitive damages because they punish the defendant. And so when a court enters a punitive damage award, it is going to be depriving a defendant of his money, of his property. And so due process requires the court to determine whether the punitive damages award is fair. So due process means fair law. So we're looking at the fairness of a punitive damages award. Usually that's just like a fairly straightforward ratio or proportion application where you take the amount of money that's being given to the plaintiff to compensate them. Like, say the plaintiff wins $10,000 from the defendant. A punitive award would be like $50,000. So some single digit multiple of the compensatory award could be granted for a punitive award. That to be considered fair, it can't get much over that single digit multiple. So they'll look at that proportion, they'll look at the nature of the defendant's conduct, they'll look at other cases where similar activity has been punished in some way by a punitive damages award. There are just various means by which the courts must consider the fairness of the award to apply due process there. Okay, now we're going to move into procedural due process. And just to remind you, now we're talking about things that government must do before it can take away a person's freedom or property. We look at that first in the context of criminal prosecutions. There are certain basic requirements of procedural due process. Notice, an opportunity to defend yourself, a hearing, and an impartial judge or jury, impartial panel. Those are the basic due process rights. Those general notions of fairness were elaborated upon in those 4 amendments, 4th, 5th, 6th, and 8th amendments that we'll study in Module 13. These, the procedural due process rights of people are also elaborated upon somewhat in court decisions where some statutes could be struck down because they don't give sufficient notice. So if a basic requirement of procedural due process is notice of what conduct you've done that was wrong, or notice of what is criminal or what is not criminal, courts will sometimes strike down criminal statutes because they're written so broadly or vaguely that it's impossible for people to know what's prohibited or what's not prohibited. Or the statute may be so broadly worded or so vaguely worded that it goes too far and it would make criminal activity that absolutely is not criminal. So there are situations where even outside the context of those specific amendments, courts have protected just basic due process requirements of notice, opportunity to defend oneself, a hearing, and an impartial jury or judge. Due process rights are also provided to juveniles. This is a development that occurred in the mid 1900s. At least that's when it started, when juvenile court systems were separated from the adult court system. At first, judges were given a lot of discretion to determine what would happen to a juvenile delinquent. And sometimes those consequences or punishments were pretty extreme. They were just as tough as an adult going to prison. It would be a child going into a detention center for a really long time. And because the punishment was the same type of punishment adults got, the due process protections needed to be the same too in order for it to be fair law, due process. Not all due process rights are granted to juveniles. Most are, but In re Galtz is the main decision where the Supreme Court kind of outlined what due process protections should be given to juveniles. And rather than learning what should be given, you just remember what isn't. The first, bail. So juveniles are not entitled to bail. They can be held in a detention center pending the outcome of their hearing, especially when they don't have a safe home to go to. So that's one due process protection they don't receive. And another is the right to a jury. Juveniles' identity is meant to be kept confidential. Juvenile records are meant to be kept sealed. So our courts protect that by not allowing a jury to determine their guilt or innocence. It's handled and it's in a very informal setting. The judge is still going to hear evidence. There are still other due process protections. You just don't have a jury deciding the outcome of the case. Roper versus Simmons is a case where the protections of the 8th Amendment were extended to juveniles, and it specifically involved the death penalty. There, the court held that juveniles who were under the age of 18 at the time they committed a crime cannot be sentenced to death. So even murder, if a juvenile committed murder before the juvenile turned 18, then that juvenile cannot be sentenced to death. And in this subsequent case, Graham versus Florida, the court said anytime a juvenile is convicted of a crime that's not homicide, like any robbery, some other type of crime, they cannot be sentenced to life without parole. You have to give an opportunity for the juvenile to demonstrate, hey, I've matured, I've learned from the consequences of my activity. I know better now. Won't do. They have to have some opportunity for parole to have their case reevaluated after they've gotten older. And now here, finally, is the procedural due process side of the coin in the context of private civil lawsuits. So before we were looking at the substantive due process application in civil lawsuits, now we're looking at the procedural due process application in civil lawsuits. Again, state action requirement easily met because the courts are involved in upholding a plaintiff's judgment against a defendant. The main way procedural due process, basic due process rights are protected is through court rules. There's a federal rules of civil procedure, a state rule of civil procedure that provide notice, the opportunity for a defendant to defend oneself. Those protections are mostly afforded in these rules of court. There are some. So the Sixth Amendment that the part of the Sixth Amendment that gives criminal defendants the right to the assistance of counsel, that Sixth Amendment protection does not apply in civil lawsuits. So don't be confused. The Sixth Amendment right to the assistance of counsel does not apply in civil lawsuits. However, several states and in some limited instances, courts will appoint an attorney for a defendant in a civil lawsuit. And the way it kind of works out is attorneys, when they become members of the Bar Association, the Bar Association requires them to do some pro bono work as just an aspect of being a member in good standing of the bar. So if a case comes before a court where an indigent or a poor individual is being sued, they can't afford to hire an attorney, the court will call on an attorney in private practice and say, I need you to take this pro bono case, come and represent this indigent defendant in this case, because we just want to make sure that basic fairness exists even in civil actions, even though the Sixth Amendment doesn't apply. Another way that procedural due process is provided has to do with jurisdiction. The courts have to justify bringing a defendant into the court and making them respond to a lawsuit. And the way they do that is by applying something called minimum contacts analysis. So that's pretty easy to do when the defendant resides in the jurisdiction of the court. If they reside there, of course, the court has jurisdiction over them and can require them to come and appear. The problem arises when a plaintiff sues an out-of-state defendant, someone who doesn't reside in the court's jurisdiction. And so when that occurs, it's up to the plaintiff to prove the defendant has performed enough activity within the state in order to justify being brought into the courts of that state. And that's not typically very hard to do. Usually that particular activity the defendant has performed in the state is the subject of the lawsuit. So it's fairly easy to establish minimum contacts analysis. But when all of the defendant's activity occurs somewhere else, and the only thing inside the state associated with that defendant is property, that's where you have to start looking at, okay, number one, is the property the subject of the dispute? Yes. Okay, then the court has jurisdiction over that property, and the defendant has to come in and defend itself in that property lawsuit. But there is a way to attach a judgment against a non-resident defendant, attach it onto property they own in a state, even if that property is not the subject of the lawsuit. It's a way to collect a judgment against an out-of-state defendant. That's called quasi-in rem jurisdiction, and it's limited to just the value of that property that is found in the court's territorial jurisdiction. So it's really just a way of enforcing a judgment. The court will attach a lien to the property of the defendant existing in that jurisdiction. And so if that defendant ever goes to try to sell the property, they have to give the money to the plaintiff who was in that lawsuit. And then the last way we have for procedural due process to apply in civil cases is through the burden of proof. In criminal cases, the burden of proof beyond a reasonable doubt. You don't have to do that in civil cases because you're not talking about putting somebody in jail. You're just talking about, the redistribution of wealth, money going from a defendant to a plaintiff. There still has to be some burden of proof. And the minimum threshold is preponderance of evidence. So that is your basic due process protection. There's a minimum threshold of a preponderance of the evidence standard of proof. It is possible to heighten that standard to clear and convincing evidence. In some situations, states have done that. I mentioned that about indigent defendants. So the last topic for this module has to do with procedural due process before government agencies. Since so much of the work of government is done in the bureaucracies of government, this becomes very relevant. Agencies are delegated the power to implement the law, so the state action element is met. But the extent of due process protection is going to vary based on the circumstances. And there were several examples given in the textbook, and you don't need to study and memorize all of them. I just want you to recognize what you're looking at is where a person has some sort of vested interest, it could be a property, like in these examples, it could be the right to have a job, a vested right to hold your job, a vested right to benefits from the government, the right to drive, the right to travel, some sort of vested right that the agency is trying to deprive you of. In those situations, you are entitled to the basic elements of due process: notice, a hearing, ability to defend yourself, an impartial jury. Those types of basic protections will apply even when it's just a government agency. And that is it for Module 9.